Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. I've mentioned before on here that Daubert motions are sometimes used by defense and sometimes even by plaintiffs to get rid of expert witness opinions they don't like. And in some of those cases, that's legitimate, and in other cases, it's not legitimate. And in some cases, as in the one we'll discuss today, the Daubert ruling was appropriate only because of the law in the state of West Virginia as it sat on the day when the judge made that decision to exclude the expert. Now, this is a case involving pelvic mesh. In the last probably 20 years, surgeons have been using mesh a lot more often to strengthen certain structures. They use it, for example, to strengthen things like abdominal hernias and inguinal hernias. They use it in hernias a lot. And they also use it in certain instances for female bladder issues. And that's where it arises in this case. Now, the judge in this case was a woman. And I'm sure that if there was a way to legally and lawfully rule in favor of the plaintiff on this, she would have done so, because I suspect she felt very badly for this woman and what she had gone through. But unfortunately for the judge, who now suffers a reversal that she really shouldn't have suffered if the West Virginia Supreme Court had come out with this ruling earlier, she nonetheless got it right at the time, and now the Fourth Circuit Court of Appeals is going to reverse that. So let's take a look at the opinion. This is Judith A. Shears and Gary F. Shears Jr. versus Ethicon and Johnson & Johnson and Ethicon LLC. Those are the defendants. And the judge is Irene M. Keeley, a senior district judge from the Northern District of West Virginia. And this was before Judges King, Agee, and Heitens in the Fourth Circuit Court of Appeals. And they note here that it's been vacated and remanded by published opinion. In this pelvic mesh products liability action on appeal from the Northern District, the federal trial court entered a judgment against the plaintiffs following a March 22 jury trial. They certified a question of law to the Supreme Court of Appeals of West Virginia regarding the plaintiff's strict liability design defect claim. Having now received the state Supreme Court's answer to our certified question, we vacate the trial court's judgment and remand for further proceedings. One of the more recent innovations in modern American law is the ability for federal courts of appeal to talk to state Supreme Courts and certify questions of law to them and have the question of law answered by the court in question, in this case, the West Virginia Supreme Court. And basically what it boils down to is, if there is a disputed question of law and what the law is or should be under the state Supreme Court's rulings to date, then what happens is they send this certification order over, the Supreme Court analyzes the issue, issues an opinion. They issue an opinion under the state court doctrine. They put it out just like they would if somebody was appealing up through the state courts. And then the U.S. Circuit Court of Appeals uses that opinion to deal with the problem. So in their April 2023 certification order, they told the Supreme Court of West Virginia this, that Ms. Shears had a problem with stress incontinence. Then she was eventually referred to a urogynecologist who treated her conditions by placing a synthetic surgical mesh sling called a tension-free vaginal tape, or TVT mesh. And after that, she began experiencing renewed incontinence, urinary tract infections, pelvic pain, along with urinary frequency and urgency. In October of 2013, a urologist discovered that the TVT mesh had partially eroded into the bladder, and an operation was performed to remove the eroded mesh and an attached bladder stone. Additional eroded mesh was discovered in her bladder in 2014, and she has since experienced recurrent bladder stones and severe associated bladder and urinary difficulties. Along with her husband, Mrs. Shears initiated this civil suit in 2013 against Ethicon. Now, keep in mind, this is 11 years later. The manufacturer and seller of the TVT mesh. As relevant to this appeal, a strict product liability claim alleging a design defect in the TVT, as well as a claim for negligent design thereof, was brought by the Shears. And Mr. Shears, for his part, joined in the lawsuit suing for a loss of consortium. Now, what does it mean when a lawyer says loss of consortium? Well, loss of consortium is essentially a loss of the value of the relationship caused by the physical strain and accompanying medical and financial burdens that arise by virtue of that kind of problem. And essentially what they're saying here is that Ethicon is legally responsible for the damage to the marital relationship suffered by the couple during the pendency of her problems with this particular mesh. So the case originally started out in an MDL court. And an MDL is a multi-district litigation court, which is when a manufacturer is sued by dozens of people all over the country for the same problem. They put it into what's called an MDL, and a lot of the common issues are resolved by the MDL court, and then the individual cases are, once that has happened, are sent back down to the district courts from whence they came. So one of the first things the judge did was address the defendant's Daubert motion. One of Ethicon's Daubert motions sought to limit the testimony of Dr. Uwe Kling, the Shears' design and materials expert. Dr. Kling's expert report spoke to two possible alternatives to the design of Ethicon's TVT mesh, specifically polyvinylidene fluoride and UltraPro. Dr. Kling expressed that in his professional opinion, those materials posed a far lower risk of erosion in pelvic tissue than the TVT mesh and represented safer alternative mesh materials for treatment of stress urinary incontinence than Ethicon's TVT Prolene mesh. Sounds like a pretty good opinion, doesn't it? My guess is that Dr. Kling was probably retained by the MDL lawyers and used in the MDL. I'm sure there were expert issues that came up there. And then, by virtue of having done that, he was available to these plaintiffs in their case in West Virginia. But, as frequently happens, the law between different states is different, and the doctor's expert report did not cover a critical issue of West Virginia law. During a hearing on the Daubert motions on February 11, 2022, the federal trial court questioned the Shears' lawyer regarding Section 411 of the Supreme Court of Appeals, West Virginia's recently published West Virginia Pattern Jury Instructions for Civil Cases, the PJI. Section 411, entitled Design Defect Necessity of an Alternative Feasible Design, provides as follows. There are many designs which, though they may eliminate a particular risk, are not practicable to produce. To prove the design is defective, the plaintiff must prove that there was an alternative feasible design that eliminated the risk of injury to him or her. Now, the language of Section 411 reflects the so-called elimination mandate. That is, a requirement that an identified alternative feasible product design eliminates the risk of harm suffered by the plaintiff. But here, the doctor had opined that it didn't eliminate the risk, it reduced the risk. And therein was the problem. Focusing on the elimination mandate, the federal trial court expressed its concern. The court accepted the legal soundness of Section 411's requirements, observing that it saw in Dr. Kling's expert report fulsome discussions about this better and safer thing, but never said the alternative mesh designs eliminated, but rather reduced the risk. Because his proposed testimony didn't meet the standards of West Virginia law and therefore would not be of use to the jury, as a result, they barred him from testifying on his proffered alternative mesh designs. So the Shearses proceeded to jury trial against Ethicon, but critically, they had to change horses in the middle of the stream. Instead of using a design defect based on an alternate practicable design, the Shearses pursued their design defect under an alternative, so-called malfunction theory of liability. As we further noted in our certification order, under West Virginia law, the malfunction theory permits success on a strict product liability claim using only circumstantial evidence, so long as the plaintiff shows that a malfunction in the product occurred that would not ordinarily happen in the absence of a defect. That really sort of bears the hallmark of res ipsa loquitur, which is an alternative way to prove negligence. You say that ordinarily this injury wouldn't have occurred but for negligence. And that's essentially what they're saying here, that this person wouldn't have been injured by this mesh, essentially without there being a defect in it. The trial court promptly ended the Shears' reliance on the malfunction theory, however, granting Ethicon's motion for judgment as a matter of law at the close of the Shears' case in chief. And then the jury returned a verdict for Ethicon on the claim later that same day. After the final entry of judgment, they filed a timely notice of appeal, and after obtaining briefing from the parties and conducting oral argument, this court, sua sponte, which means on the court's own motion. That's what it means when a court says sua sponte. It means we're doing this because we want to do it, not because anybody told us to do it. So the court sua sponte availed itself of the privilege afforded by the state of West Virginia through the Uniform Certifications of Questions of Law Act, which is the act I mentioned earlier that allows you to go get essentially a free read from the West Virginia Supreme Court. Focusing on Section 411, they proposed certain questions. Whether Section 411 of the PJI was correctly specifying the plaintiff's burden of proof for strict liability at trial under West Virginia law, and more specifically, whether the plaintiff alleging a West Virginia strict liability design defect claim is required to prove the existence of an alternative feasible product design existing at the time of the subject product's manufacture in order to establish that the product was not reasonably safe for its intended use, and if so, whether the alternative feasible product design must eliminate the risk of harm suffered by the plaintiff, or whether a reduction of risk is sufficient. In a unanimous June 2024 opinion delivered by Justice C. Haley Bunn, the Supreme Court of West Virginia exercised its discretion to accept and rephrase our question of law. They answered whether it was a proper statement of law by saying no. They answered whether or not there had to be an alternative feasible product design by saying yes. And asking if the feasible product design must eliminate the risk, they said, as part of a prima facie case of strict product liability based on a design defect, a plaintiff is required to prove that an alternative feasible design existing at the time the subject product was made would have substantially reduced the risk of specific injury suffered by the plaintiff. So the opinion quotes two syllabus points, and syllabus points are used in West Virginia to announce an important new point of law decided in the case. And the first point was 411 doesn't correctly specify the plaintiff's burden of proof. And the fifth one was, as part of the prima facie case, all you have to do basically is show that it would reduce the risk, not eliminated it. So we have adopted that. Specifically, the Shearses assert that the trial court's Daubert ruling is legally unsound because it restricted the expert testimony based on a requirement that does not exist in West Virginia law, the elimination mandate. It is settled that we review a trial court's decision on the admissibility of expert testimony for abuse of discretion. And a court abuses its discretion when its conclusions are guided by erroneous legal principles. But that error is subject to harmless error review, meaning if this would not have made a difference in the grand scheme of things, forget it, we're not reversing. An error is harmless when this court is satisfied, with fair assurance after pondering all that happened, without stripping the erroneous action from the whole, that the judgment was not substantially swayed by the errors. And here, by its Daubert ruling, the federal court excluded proposed testimony. And in ruling that Dr. Kling's testimony doesn't meet the standard, the court relied on this erroneous elimination mandate. The opinion of the Supreme Court establishes that the federal trial court abused its discretion by relying on an erroneous legal principle. So there's no support in West Virginia law for that requirement, and as a result, we are satisfied that the trial court's exclusion readily satisfies the harmless error review analysis. And what's that mean? It means that pursuant to the foregoing, we vacate the judgment of the federal trial court and remand for such other and further proceedings as may be appropriate. Vacated and remanded. Now, about 5 or 6 years ago, in a case against Ford Motor Company for unintended acceleration, we took an appeal up to the Fourth Circuit on a Daubert issue, and we had some really good experts, and the expert opinions we believed were very sound. They were based on good science, and the trial judge had refused to accept them. He Dauberted our expert out, and as a result, we lost any opportunity to proceed. We lost on summary judgment. We took that up before the Fourth Circuit, and the Fourth Circuit said, "Sorry, Charlie." So I am a little bit relieved to see that the Fourth Circuit has relaxed to a certain extent its rather cribbed view of the Daubert standard and how it applies when you're dealing with expert witnesses who may not necessarily be familiar with the state law, but who know the area of expertise better than just about anybody. In my opinion, this is a good case, and it's good for a number of reasons. And one of those reasons is that one of the things that plaintiffs' attorneys are often criticized for in medical cases is that, we're forcing doctors out of business. We're making them do all kinds of unnecessary tests. And that's not true. But you can understand how the public would have a great deal of sympathy for doctors because they are out there doing their thing. They're saving lives, making people better every day. And any time that you have a lawsuit, I'm certain it takes away from the doctor's time to treat his patients. So there is some relevance in that regard. But a product liability suit is greatly different than that. It says the doctor didn't do anything wrong. He trusted that the manufacturer was correct in its product descriptions and in its assertions that this would work in the way that it said it would work. And that didn't happen. So in these cases, often the surgeon is the best witness for the particular plaintiff. But unfortunately, some states do have laws that are extremely restrictive in product design defect cases, just like West Virginia's law was. So it's good to see that West Virginia is also modernizing its law with respect to this issue. So that's what I have for you today. Hopefully you found this interesting, and we've had an opportunity to talk about a couple of different things: design defect claims, sua sponte issues, that sort of thing. If you have any questions, drop them in the comments down below. Like, share, subscribe, all the stuff we ask you to do. And if you have the opportunity today, go out of your way, do something nice for somebody. And then come on back tomorrow, catch me down here at the beach. We'll talk about something else. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.